speech registration. Today, Mr. Thomas Ayers will do the presentation on the third level. Thank you.
Thank you very much, Mrs.
I am Carlies Knudsen. I'm the Chief Registrar of the... Thank you.
Thank you, Carlies. Members, do we adopt those apologies?
Yes, Chair. PP adopts those apologies. Thanks.
Thank you. Any seconder?
Chairperson, I rise to second the acceptance of those apologies. And this is Zolani Mkiva. Thank you.
Very much, Honorable Mkiva. Now we go to the agenda, the item itself.
I will put it on the screen now, Chair.
Yes. Before we go to those, okay. Yeah, you can put it on the screen so that we can continue with.
Okay. Can I continue, Chair?
Yes, sir.
Okay, Chair. I've contacted all provinces just to update the committee as far as briefings and public hearing. Can everybody see the screen, Chair?
Yes, Aska, we can see it. Thank you.
Eastern Cape had their briefing on the 31st of May. Their public hearings will be from the 23rd to the 26th of August across the province. Free State had their briefing on the 24th of April. Their public hearings will be 11, 12, 16, 17, 18 August 22. Gauteng had their briefing the 1st of June and will have their public hearings 16 and 23rd August. KZN had their briefing on the 8th of June. They've had their public hearings 30 June, 22, 2, 9, 12, 13, 15, 16 July. Limpopo province will have theirs on the 4th of August, and their public hearings will be 15 and 29. Mpumalanga had their briefing on the 4th of July, and the public hearings will be 2, 3, 16 August. Northern Cape had their briefing on the 7th of June. They have not yet indicated anything about public hearings or whether they're just going to call for public comment. Northwest has not indicated anything about briefings, nor public hearings, or calling for public comment as yet. Western Cape had their briefing on the 24th of May, and on the 10th of June, the Western Cape Legislature called for public comment, which closed on the 4th of July. Chairperson, that is my part as far as the updates are concerned. Thank you, Chair. Chairperson, shall I put up the next document for Cobus just to go through the brief? Chairperson?
Yes, I can hear you now.
Must I put up the next document just so that Cobus can go through it and then we can proceed?
Honorable Chair, just before, Honorable Chair.
Honorable Smith?
Yeah, my apology. I've raised my hand, but I think you might not have seen it. I just want to ask her just to display the full document again on the screen. I missed the first part.
Okay. Can I stop sharing?
Oscar, is it possible that you can make it a full screen? Sorry.
That is a full screen.
Honorable Smith, on your side,
I
you
can
can make
email
it
it to you.
full.
I can email the document to you, sir. It's not a problem.
Thank you. Thank you very much.
Can we continue, Chair? Ma'am Gwenia's hand is also up, Chair.
Ma'am Gwenya?
Thanks very much, Chair. You'll correct me maybe if I'm wrong on the document that Aska have read it for us. I've got additional, Chair. Can I or must I wait for this other document?
No, you can, ma'am.
Thanks very much, Chairperson. And thank you for the presentation that Aska have presented to us. Honorable Chairperson, as a permanent delegate presented Gauteng in this committee, I would to confirm to the committee that Gauteng has a plan, a schedule for the public hearing on the sectional titles amendment bill. One, Chair, our first public hearing will take on the 16th August 2022 from 10 o'clock to 14 hours. This public hearing will be conducted virtual. The second public hearing will take place on the 23rd August 2022 from 10 o'clock to 14 hours. This venue will be Parktonian Hotel in Braamfontein. The National Department of Agriculture has confirmed that its officials will be present in all our public hearing. I thank you, Chairperson. That's my submission, Chair.
Thank you very much, ma'am, for your detailed briefing. Anyone from the province that he or she would like to give us the information about her or his province? None. We can continue.
Thank you, Chair. I will share Corbus's document and he will go through it.
Firstly, department, I've seen, it looks like the DG is in the meeting. DG is in the meeting?
Yes, I am, Honorable Chair, and willing to participate in terms of the engagements. Thank you very much.
No, you are welcome, sir. I wanted to welcome you because in the beginning I didn't see you when Karim was talking. I thought she's the leader of the delegates, but you are welcome, DG, to our meeting. Yes, you can continue, Askam.
Yes, Chair, I'm just looking for the document. There we go. Corbus.
Good morning. Can everybody hear me?
Yeah,
Yeah.
can hear you, Kobas.
Thanks, Chair. Good morning to everybody in the meeting. I'm just quickly going to run through the objects of the bill. It is a very short one-page document, as the bill is not containing a massive amount of amendments. Basically, the sectional titles amendment, or the Sectional Titles Act, in terms of Section 54 of the Act, has established a Sectional Titles Regulation Board, and the board reviews the Act periodically. And as a result of the most recent review, the board had proposed the amendments contained in this bill. The proposed amendments seek to improve the registration and surveying related matters in deeds registries and the offices of the Surveyor General. Therefore, it's a very focused set of amendments. It is not general at all. And the following user groups are most likely to be affected by the amendments, but the aim of the amendments are to benefit these groups. It is sectional title developers, owners of sectional title units, and financial institutions are affected by the bill. The objects or aims of the amendment bill is strengthening the rights of lessees in development schemes, clarifying the rights of developers in respect of the subdivision, consolidation, and extension of units in sectional title schemes, and by providing for the consent of mortgagees in respect of leases of common property. As it is a very focused group of individuals affected by the bill, consultation on the Sectional Title Amendment Bill took place with the following individuals or groups: the Sectional Title Regulations Board, represented by the Law Society of South Africa, Legal Practice Council of South Africa, South African Council for Architectural Professions, South African Council for Professional and Technical Surveyors, the Banking Association of South Africa, the Institute for Estate Agents of South Africa, and the National Association of Managing Agents. And the bill and the memorandum on the objects of the bill were published for general comments quite some time ago, Gazette number 40951, under government notice number 60 or 623 of 2017, and is dated the 30th of June 2017. So this is the end of the document, just briefly introducing the objects of the bill.
Recording in progress.
Thank you.
Thank you very much, Aska. Members? Or Mr. Kobas, anything to add, or let me get information again, presentation from the department? DG?
Thank you very much, Honorable Chair and Honorable Members. As previously indicated, we have noted the inputs that came through, and the department has crafted the responses that would be in line with the inputs that were made, specifically around the Sectional Title Amendments Bill. And therefore, I'll hand over to Mr. Thomas S., who will be giving the presentation on behalf of the department. Thank you very much, Chair.
Good.
Thank you, Chairperson, DG, honorable members. Yes, thank you for the response or the inputs we received from Western Cape. And we have duly responded to the inputs and proposals. And if we can then go please to the second page. We have the official response on the right-hand side, but also to inform or to convey and what informs our official response. I will nevertheless also refer to all three of the bullets. Now, our official response is that we note the comment or the input, but we do say that the bill was edited and was certified and found to be in order by the Office of the Chief State Law Advisor. Now, regarding the first bullet, the statement there is that the word hereby is used throughout the bill, and this should be deleted as it is an outdated word. That statement is 100% correct. However, one must bear in mind that the word hereby is not only used throughout the bill, it is used throughout the Act. So currently, by using the word hereby, the bill is consistent with the Act as it reads at present. However, this particular aspect and other outdated words will be attended to as part of our transformative legislative process. Then the second bullet, some of the proposed provisions are lengthy and could be difficult for the public to understand. And as example, clause 4 is given. The clause 4 in particular then now does not speak to the public. It talks to the registrar. And it is necessary to word that provision the way it is worded in order to ensure that there are administrative certainty. And then in the third bullet, yes, we agree and we note that that particular input. We go to that was now the general remarks. Now regarding clause 2. If we look at the bill, clause 2 seeks to amend section 4 of the Act to enable lessees to appoint representatives. Intention there is that they can then appoint a knowledgeable person to represent them at the meetings. That is what the bill, that's the nature of the amendment proposed and what needs, we seek to achieve by amending section 4. We received a number of inputs from Western Cape. That does not speak to the nature of the proposed amendment, but in fact, it is additional proposals as such. Now, let's look at each of the bullet points. Regarding meetings with lessees, need to be announced timelessly and at a reasonable location. And then the recommendation is that it must be outlined in an annexure. The requirements of the meeting with the lessees needs to be announced timelessly and a reasonable location. And it must be clearly stated that would constitute a timeless announcement, as well as what the determining factor would be for a meeting location to be determined. Now, this particular aspect is addressed already in section 4.3a. If one look at the provision of section 4.3b, there's a clear link between 4.3b and 4.3a. 4.3b refers to the meeting contemplated in section 4.3a. So nothing wrong with the proposal. It's just that the Act already caters and meet all those requirements referred to. The second bullet, lessees need to be trained, educated on their roles and responsibilities and position in relation to the body corporate before signing the contract. So the recommendation is that lessees need to be designed for having participated and understood the education regarding their roles and responsibilities and position in relation to the body corporate before signing the contract. Now, our response there, the roles and responsibilities and position of owners of units in relation to the body corporate are aspects that fall under the Sectional Title Management Act, that is Act 8 of 2011, which act is being administered by the Department of Human Settlement. So this proposal, additional proposal, our official response is we cannot cater for this aspect in the Sectional Titles Act. The appropriate legislation will be the Sectional Title Management Schemes Act. Go over to the next bullet. The purpose of the meeting should be clearly explained in layman's terms and be available in writing. It is recommended that there is a requirement to include the purpose of the meeting to be clearly explained in layman's terms, and this should be available in writing. Now, also we don't support this particular proposal, seeing that Section 4.3a must be read with Section 10. There's already Section 10 explains the nature of the meeting. It specifies it must be in writing. So whatever is proposed here is already contained in the Act, Section 4.3a, read with Section 10. The next bullet, owing to possible language differences within an area, language differences may cause a communication barrier at meetings. And then the proposal is, in cases where language could prove to be a challenge, it is recommended that a suitable translator be available to assist lessees in the language most commonly spoken in that area. Now, at the meeting, the developer or the developer's attorney, conveyancer, must answer all questions. And our official response here is we noted that language matters must be addressed by the developer with the answering of questions as contemplated in Section 4.3b of the Act. The next bullet, lessees have to understand the roles and functions of the body corporate in order to undertake their expected roles and functions, which will ensure effective management of their development and that the body corporate functions optimally. It is recommended that the roles and functions of the body corporate be outlined and clarified in to the lessee before or as early into the registration of the body corporate as possible. So once again, this is not a matter that can be addressed in the Sectional Titles Act. The appropriate act or legislation is the Sectional Title Schemes Management Act, which falls under the Department of Human Settlement. Next bullet. To ensure transparency and record management, the feedback from the meeting needs to be published and distributed. Okay, that is the recommendation. Our official response is, it is not clear where the feedback must be published and to whom it must be distributed. Given the purpose of the meeting, and in that regard, one must look at Section 4.3, read with Section 10. It is also not clear what the nature and purpose of the feedback should be. I think if we focus here on the purpose of the meeting, then the feedback becomes questionable. To whom must feedback be given? Feedback will be given to each lessee on a continual basis. That is an obligation under the Act, Section 10. So, yeah, in this regard, we do not support the proposal. And the last proposal from the side of Western Cape Government relates to Section 17, and that is Clause 4B, Cap B, Sub A of the bill, where they say it is noted that the words or part thereof were omitted in the fourth line of the proposed subsection, and they ask we must just consider whether the words or part thereof, which appear early in the section, should also be omitted. No, the amendment to Section 17.4 Cap B Sub A, in Clause 4B, is in fact correct. The first or part thereof contained in the second line relates to circumstances which affects both the whole of an exclusive use area or part thereof, whilst the reference to or part thereof in the fourth line relates to actions to be taken. And the action must only relate to the whole of an exclusive use area. So thank you for that question. However, the particular amendment is correct. Thank you, Chair.
We thank you very much, Chair. We submit.
Okay, thank you very much, DG and your team. Now it's your time, honorable members. If you want to ask questions or any clarity, you can do so. I'll see by hand, okay. I can see the hand of Honorable Suya, Honorable Smith. Those are the two hands that I have now.
I also have.
Honorable Kiv.
Thank you.
I know he's there at the. He cannot raise his hand because of the network. And who else again? Yeah, those are the three hands. You can start, Mr. or Miss Suraya.
Good morning, Chairperson. Good morning, members. My name is Suraya Williams. I'm from the Office of the Chief State Law Advisor. We certified this bill before the bill was introduced in Parliament. Chair, and if I may, I'd just like to respond to the one comment that was raised with regard to the language, the use of the word hereby, Chair, if I may proceed.
You can, ma'am.
Okay, thanks, Chair. Chair, the one concern with regard to the use of the word hereby, the use of the word hereby is usually used in official statements or proclamations. And if you look at the amendment bill, the word hereby is only used in the headings. For example, when we say Section 21 of the Principal Act is hereby amended by the insertion after the subsection, this act is hereby amended. It's only used in that, and that is consistent with drafting form and style, with legislative drafting practices. And the purpose of that is, as I said earlier, it's usually used in official statements or proclamations. Once the bill has been passed by Parliament, it goes to the President for assent. So when it goes to the President for assent, it shows that these provisions are hereby given effect to, and it becomes part of the Principal Act. So the wording hereby, when we introduce the various amendments, it won't be part of the Principal Act. It is not part of the amendments, but it's merely a statement to say that as a result of this amendment, the Principal Act will be changing, and this will replace, substitute, or amend the provisions in the Principal Act. So the word hereby in itself will not form part of the Principal Act, but merely as a part of the official statement to indicate the proposed amendments or the amendment made to the Principal Act. Thanks, Chair.
Thank you very much, Ms. Suraya. Suraya.
Suraya, Chair.
Okay, thank you, ma'am. Thank you. Honorable Smith.
Thank you, Chair. I don't want to make any comments relating to the presentation. I just want to ask, up front, because I've got experience from previous bills in terms of negotiating mandates. And I want to make a proposal that whenever there is when we're going to move towards the negotiating mandates, that each province's amendments being sent to all the other provinces so that they can actually say whether they support or oppose each one of the amendments or proposals by various provinces. So that when we get there, because what happens normally is when you don't have a mandate on a specific amendment by another province, then the other provinces either abstain or vote against it without considering, that amendment. So it's just a proposal, that we really consider each and every amendment or proposal by various provinces within each province. So when they give us a mandate, they give us a mandate in terms of their proposals, but also a mandate in terms of other provinces' proposals, whether we should support or reject or abstain from such amendments or suggestions. So it's just a proposal to make the process more seamless and and more efficient. Thank you, Chair.
Honorable Smith, you are noted, but I don't think we are going to change how we used to do other bills, because if we were saying that it will take the provincial, as somewhere that we don't want to go, but I don't discuss it. We will discuss in the right time, not now. Any member? Oh, Honorable Mkiva, your hand was up.
No, thank you, Chairperson. No, I wanted just to say, Chair, also just maybe for the purposes of improving in terms of the work that we are doing as a lawmaking institution. Laws and the amendments to laws, they ought to talk to the cultural outlook of its own people. In other words, laws are embedded on culture and should also be pregnant with culture. In the majority of cases, therefore, they should not contradict the cultural outlook of the people. And one of the fundamentals in order to ensure that that does not happen, the actual writing of the amendments ideally should be flowing from an indigenous language or indigenous languages, because there are commonalities amongst them. And then they then get translated into English. Now, listening to the presentation here, where you have things like hereby, thereby, whatever, it would be almost seamless, the process of doing that. So I would want, therefore, my first question to ask if these amendments are a translation from an indigenous perspective, or what has been presented here, it was just written from scratch in English, and then it will then be made available in the indigenous languages. That's my first question. The second question is, this presentation that was being presented now here, this is now a direct question. Is it also available in any of the 9 indigenous languages, so then that I am able to compare and contrast between what is presented in English and what possibly could be presented in Zulu? Thank you very much, Chair.
Thank you very much, Honorable Kiva. Anyone? You see, I'm going to have a problem. I've seen the hand, but this hand is for 21-9. There are numbers only. There's no name.
Good morning, Chair. My name is Daniel Pinar. My apologies. We mostly meet in teams. Therefore, 2192 is not my real name. I suppose you're using Zoom now. I can't comment on the last bit of the presentation, but in the way of the department's interpretation, comments on the rest of our comments raised, I want to say that I take note of them. I think it's fair. And I want to thank the department for taking the time to consider them. Thank you very much.
Thank you very much, Mr.
Daniel Pinar.
Oh, Mr. Daniel Pinar.
Western Cape Human Settlements, man.
Oh, okay. Thank you very much, man. Say. Yes.
No, Chair, I just wanted to say just to help the member from the Western Cape, he needs to rename his gadgets. There is an icon that can help him to do that so that we know who we are referring to, and also to help you for ease of reference.
Thanks, Honorable Kiva, to assist the Honorable Member from Western Cape, Mr. Daniel Pinera, to rename his gadget, because next time I am not going to allow him to speak in the meeting with these numbers. Honorable Smith, I can see your orange hand.
It's not an orange hand, Chair, it's a brown hand.
Whatever.
Chairperson, I just want to say that I take note of your comments on my recommendation. I just want to ask then that it be referred to a next meeting, and then if necessary, we can also get the input from, from the advisors, whether legal or procedural or whatever.
Okay.
Whether that can be considered or not, that we have a discussion with it within the next meeting, so that we can get clarity on that, because I feel that my proposal has got merits, although you disagree. Thank you, Chair.
Thank you very much, Honorable Smith. Mema Pamela Masiko Kambala.
Good morning, members. In the Department of Human Settlements, also in the Policy and Research Unit. I just had a direct question, if you don't mind, to the presenter of this, the person who made this presentation. It's in relation to slide 3. The comment, I don't know if you want to put it up for all the members to see before I proceed with my question.
Aska, can you put it up on the screen before Mema Kambala asks a question? Aska?
It's up, Chair.
Can you put the presentation? Oh, okay.
Okay, so let me just put it, view mine on a full screen. It was the one on the, I don't think this is, can you go to the one after this one? Yes, yeah, that's the one. So yes, there's this one. So on the second bullet, I'm just reading the comment you made on the right. So I don't know if we were also confused on the definition or the use of the words lessees, because your response is talking to the roles and responsibilities and position of owners. And owners in this context would be lessors, if I'm correct. So the comment might still be relevant, even if we're talking to lessees, but I just wanted for you to just comment on whether you meant, you read the lessees as lessors in the left, and hence your response on the right with your comments, or or if our understanding is incorrect. Because we are asking for lessees to be educated or trained, right? Which are the tenants. And then your response is responding on the roles of the owners. Are you saying that it's the owner's responsibility to make sure that their tenants are, equipped
and understand the roles and responsibilities in these body corporates if they were to attend them, or what?
Chair, may I respond?
You are welcome to respond, sir.
Yeah, thank you. Okay, the input read as follows. Lessees need to be trained, educated. So with lessees, of course, we're referring to tenants. Need to be trained, educated on their roles and responsibilities and positioned in relation to the body corporate before signing the contract. Now, a lessee can also be a member of the body corporate if it's a long-term lease. Furthermore, in terms of the rules, I'm talking about the management rules and the rules of conduct. A lessee must abide by rules. So, yes, there are certain responsibilities and there's certain obligations regarding lessees. I'm definitely not referring to lessors. Remember, this is an input from Western Cape. We are merely answering their question and seeing that the management aspect falls under the Sectional Title Management Act, which includes rules and compliance with rules and so forth. That is squarely a matter to be addressed in that act, and it cannot be addressed in the Sectional Titles Act. I trust that this will suffice. Thank you.
Okay. Hello. Hello.
Yes, Chair, you may.
Hello. Can you hear me?
Can you hear me?
We can hear you, ma'am.
Okay. So, Honorable Smith, is it the old hand or it's a recent hand?
My apology, Chair, it's the old hand.
Okay, no, thanks. Now, it seems members are satisfied with the answers. I'll give back to Aska to clarify something if there are something. Yes, we had the state law advisor and then a legal advisor from Parliament. Are they in the meeting?
Yes, Chair. The legal advisors of both the state law and Parliament are present.
Can they say something before I can give back to you?
Yes, Chairperson. To Isaac, and I am the legal advisor for Parliament. Chairperson, I followed the presentations and the comment from the state law advisor, and I don't have any. Thank you.
Okay. Now it's Aska. Do you want to say something to conclude?
No, Chair, I'm covered. All we have to do is adopt the minutes and update members on the oversight. That's it, Chair.
Okay. Honorable members, let me take this opportunity to thank the department.
Sorry, Chair.
Yes, and that Honorable King.
No, but I did not hear them answering the questions. They only answered the last question.
Oh.
Chairperson, Mr. Ayers is not able to raise his hand, but he indicated to me that he will respond to Honorable Makiva's question on the languages, the translation into languages, if you allow. Thank you.
Please come on the platform.
Thank you, Chair. Regarding the question in which language this particular bill was drafted, it was drafted in English. I think that was the first aspect. And I think the second aspect was whether the response or this presentation is available in any other language. Now, unfortunately, it's only available in English. However, it is not impossible, of course, to translate it or to have it translated into Zulu. That will mean that we will also have to translate the actual inputs, whereas we should only make, in my view, make it available in a different language if the question is posed in that language. But I'm sure we can facilitate this. If there's a need, sure, we can attend to this aspect. Thank you, Chair.
Thank you very much, Sir. But you know, especially when we come to the bills, we requested Parliament to make sure that they translate all the bills in the language that our community members will be able to read and understand them, so that tomorrow they must not point fingers to us to say, you members of Parliament, we didn't understand the language. So that's why we have agreed. So I will plead to Parliament to make sure that they try their best level to translate all the bills. Before we can go to public hearing, they must translate the bills with our languages so that we can understand. Even the member at the rural area, there in the community, they must feel free to participate. Because sometimes we take the bill in those English, big English, to the public hearing. They will agree or they will put their own thing. That's why sometimes the public hearing, they ended up with else, because they will come with their own thing, with their own understanding. So please try to translate it. Aska will give you the date of the public hearing to the different provinces. So make sure that when they go to the public hearing, they must have those languages. I mean, they must have the bill in their own language so that we can have something that's very, very tangible. Honorable Chief, I don't know whether did you understand, you find the answers that Honorable, State Law Advisor, Parliament has given us.
Chair, no, I did hear his response, but he did not get into the bottom of the first question which I was asking. In other words, he seems to say that the process of writing the laws and the amendments is done in English. And that's where I have a fundamental problem, that we are only reduced into consuming a translation of a law that has been written in English. It only gets translated. What I'm trying to say is that they don't write sometimes laws in Setswana and then they translate them into English. It's always the one-way traffic, that it's first in English and then everything else is translated, as if English is a superior language than other official languages. Why don't they write sometimes in Setswana so that we can have an appreciation of an original principal law written in Setswana, and then we can then get that translation into other languages? Why does it always have to be English, as if we're an English country?
I think they have noted your point. Next time they will do that. They will write in our language and then translate to English or Afrikaans. Okay. I can see the hands of Kazim.
Chairperson, my own understanding is that if a particular act was originally drafted in a specific language, and I think that is perhaps also what Mr. Ayers tried to convey. Let's say it was Afrikaans or any other language, then your amendment bill must be in that same language as the original act. But maybe the state law advisors can advise us on this matter, because that is what we always do. We look at the principal act, what language was it drafted in, and then our amendment bill will be drafted in the same language. In our specific branch deeds registration, we actually do work with language services on a national level to do focus on making everything, of course, available in all languages, but we are not yet there, and we follow the rule that we know for drafting of legislation, but we can be corrected in this regard. Thank you, Chairperson.
Thank you very much, ma'am. That one, as a member of parliament that are representing the community down there, I will not agree with you to say, what is the problem if you amend in our language? Because now we are translating we are amending the bills. You are noted, DG. We are we are amending the bill with an English language. You can amend it in Xhosa, we can amend it in Setswana, you can amend it in other languages. That one, I don't agree. As a member of the community, as a member of NCOP. DG?
No, thank you, Honorable Chairperson and Honorable Kiva, for the issues that have been raised. I think Chairperson has answered that. I think the incisive issue that is being raised by Honorable Kiva is to say, why don't we start considering legal drafting in indigenous languages so that when we do the translations, they can go to English? That's the issue, and I don't think that at this stage, my understanding was that it's a challenge that is being thrown to us from government, those who are drafters, to think about how do we then infuse this challenge that has been thrown to us. And that's the way that I viewed this challenge to us, Honorable Mudisa, and I agree with your sentiments that you have just outlined, that we can do better in terms of the way that we do legal drafting. Thank you.
Thank you very much, DG. Now, because all the questions have been answered, honorable members, let me take this opportunity to thank the department from Rural Development, Agriculture, and also the department from, I had someone from local government or housing, other department that human settlement that in the meeting. We thank you very much for participating and to come and present to us and answer the questions that we have raised as a member of parliament, and to answer the questions from Western Cape Department. We thank you very much and your participation. The legal advisors, state law advisors, we thank you. Before you leave, I don't know, DG, do you want to say something before you leave?
No, thank you very much, Honorable Chair. We don't have anything else to say. We thank the opportunity that was given for the department to respond to the issues that were raised by the Western Cape government. Thank you very much, Chair. Thank you very much, honorable members of the Select Committee.
Thank you. You can leave the meeting now so that we can continue with the business of our committee. All the members that are from provincial legislature, you can leave the meeting so that we can continue with our business of our committee. Have they left, all of them?
If they don't want to leave, they can just rescind and go and sit in the gallery.
No, most people have left, just in-house people.
Okay, no, thanks. Aska, can we continue with the...
I'm just checking if we correct for voting, and is Mr. Mkiva? Yes, Chair, we correct. So we can adopt the minutes.
Honorable members, did you receive our previous minutes on time?
Yes, we did, Chairperson, and I move for the adoption of the minutes.
Okay. Honorable BB, move for the adoption of the minutes. Any seconder?
Chairperson, this is Zolani Mkiva. I rise to second the Honorable BB on the adoption of those minutes. Thank you very much.
Thank you very much. Previous minutes have been adopted. Now I will ask Aska to brief us about our oversight. That
can I proceed?
In the 15th of August to Northern Cape.
Can I proceed, Chair?
Yes, sir. Yes, sir.
Okay, thank you, Chair. Chair, the application has been approved politically. It is currently in the funding process where the funding has to be approved. But in the meantime, we have continued with the logistical arrangements. The trip will start off at your respective provinces. Members will fly to Gauteng. From there, we will take a flight to Khartoum. We will arrive Monday. We will have meetings on Tuesday. I've been in contact with the municipal manager, Mr. Lesarwane, from the Khartoum Kamakhara local municipality. And we are in communication with what is expected of how they can assist us. So we will start off in Khartoum. We will then drive on Wednesday on Tuesday, after the meeting, we will drive down to Uppington. Wednesday morning, we will then drive to Ugrabis. That is there's another local municipality, I forget the name, but I have spoken to the acting municipal manager, Mr. Cordom, in Ugrabis, and his secretary, Mr. Springbok. So everything in Ugrabis has been sorted out and they're busy assisting us. We drive back on Wednesday to Uppington, where we will be staying for the 2 days. On Thursday, we will be having 2 meetings with local government departments, national department in Uppington. The Uppington is the David Kruiper local municipality. We have not received any communication from them yet. I have sent them numerous emails that I'm following up again after this meeting. But the municipal manager there is Mr. Elias Ntoba, and Ms. Nicolene Suzal is his executive secretary. So I am also in email communication, but not verbal, because they have not come back to me. The Khartoum and Ugrabis, they've come back to me and we are working on things. Friday is the departure. We will leave from Uppington for our respective provinces. Thank you, Chair.
Thank you very much for the update of our oversight, though you didn't even tell members or to say the topic, what are we going to do for those.
No problem, Chair. I can put up the program. Let me just get the program. It's not a problem. My apologies on that.
Okay.
Chairperson, if Oscar is more comfortable with me highlighting the focus of the topics, I can also run through it.
Can you assist?
I will put it up for Quibus. I think my voice is about to go. My apologies on this.
About to go now. I can hear.
There we go, Chair.
Quibus?
Thank you, Chair. The focus areas of the oversight, firstly, is the Northern Cape province, where the committee has not been able to do a large amount of oversight. Focus has been in other provinces in the last few years. And also the focus of individual visits is also away from the specific normal challenges that the committee has focused on of late. There has been focus on social and labor plans of mines, on agri-parks, and on agricultural post-settlement support of land reform. Although these topics are important, the design of this oversight focuses on some of the other themes that the committee is also focused on in terms of the strategic plan. Day one of meetings in Katu is focusing specifically on public engagement related to mining affected communities, small-scale miners, interest in small-scale mining from these communities, and the general perception of the benefit of mining for the local communities. In the past, the committee was typically briefed by the department on how they incorporate local business and local communities in mining activity and what opportunities are created. But the committee has received fairly limited input from the public as to how they perceive that position that the department has. Therefore, the design of this engagement is more community focused and less departmental policy focused. The next topic of focus, sorry, Oscar, can you scroll down to the next day 3? Thank you. The focus of day 3, although land claims related, is not entirely on rural development and land reforms portfolio. The history of the Rimfasmark community claim dates back to 1994, when the restitution of land claimed by the community was approved. A large portion of land claimed was part then of the Agrabis National Park. And due to the laws pertaining to national parks, deproclamation is only allowed if Parliament approves the deproclamation. In the early 2000s, around 2004, the deproclamation was approved with the condition that the land remains used for conservation or ecotourism purposes, and that should be overseen by Parliament periodically. The interest or the focus of this oversight is to determine how government has been able to assist this community in particular to reach these goals that they themselves have approved and the objectives that Parliament had stipulated for the deproclamation to take place. The community would be asked for the input as to how their community conservation efforts have progressed and how government has been able to assist them with these developments and plans that they have had. Obviously, the Department of Environmental Affairs, well, DFFE, as well as rural agriculture, rural development, and land reform are also in a position to supply input and will be requested to supply input, but the main focus, my apologies, there's just a truck going past my house. Okay, the main focus of the oversight is to see how the trusts have benefited from the land and how government is able to support recipients of land reform if they are not focusing on agriculture or housing development, because the committee has not done oversight on such a reform process yet. On day 4, the Thursday, the committee is scheduled to meet with the local government of David Kruiper municipality. And the key points of interest is waste management, which is a local government competency, and the supply of electricity to rural communities. If we look at the David Kruiper municipality, it is massive. It's about 44,000 square kilometers, reaching up all the way to the border with Namibia and Botswana. And the communities are small and scattered throughout this municipality. Thus, the challenges of waste management, of creating local recycling opportunities, and in general, the funding of this activity is immense. It is not like a urban local government with a large amount of rates income and the ability to access a fair amount of government support in terms of MIG funding and other programs such as that, which obviously often have to be co-funded. And if a municipality is struggling with income to begin with, even co-funded government support could be a challenge. The electricity supply is a focus of the Department of Minerals and Energy, which in a earlier integrated resource plan, the IRPs that are published every 5 years, in a earlier plan dating back roughly to 2015 to 2019, it was proposed that the rural communities, about 7% of South African rural communities that cannot be linked to the grid, should be assisted with other forms of electricity supply. The Northern Cape is also the site of some of the biggest renewable energy developments of late, sponsored by government or paid for by private enterprise. But the focus of the oversight is to see if there is any movement on the initial plan to support rural local communities with off-grid electricity solutions as proposed by government at the beginning phases of integrated resource plan development. So that is basically, and also as an additional comment, public hearings will raise issues that are not the specific focus of the oversight, and those will be captured as well. But in terms of the planned oversight, those are the plans for the days in which the committee is not traveling, where engagements will take place. So from my side, Chair, that is the input of the plans, and Oscar and myself can supply follow-ups on the questions that might arise. Thank you, Chair.
No, thank you very much, Mr. Jooste. Leave the presentation on the screen, Oscar. Don't remove it. Honorable members, I put the oversight plan for our next 2 weeks to Northern Cape in front of you, but also we'll still send to you this document so that when we get there, we must not come there just we are going to do oversight, not knowing the key issues that we are going to raise or the key issues that we are going to communicate with our community members. I don't know any clarity in this program, members. We have any clarity or any question?
Chairperson Ngwenya.
Yes, Mangwenya.
Chair, I don't think maybe it's a clarity, but it's a request to have this program in our email, please. I was asking that, Chair.
Oscar, can you to the all members to the email and the background? The background is very key, very important for members to know that. And then, honorable members, if you don't have any clarity, oh, Mama Bibi, Honorable Bibi.
Thank you, Chairperson. Mine one is on the 18th, which is Thursday, of which I think we have got questions to the deputy, to the deputy president. So I'm just checking at that time because with our, with the messages that we got from the Chief Whip's office saying that all members that are going to be on the oversight visits on that date, we must reserve 2 o'clock time, and we must go back to our hotels to log in because we'll be having that session of of the questions from the Deputy President. So I'm just thinking, I mean, how can we juggle around that? Thank you, Chairperson.
Thank you very much, Honorable Vivi. I requested Aska to for Tuesday. Is it Tuesday or Thursday? When is the Deputy President questions? Is it Tuesday, Mambibi, or Thursday?
It's Thursday on the 18th at 2 o'clock.
Okay. No, it means 2 o'clock meeting, it will be 5 o'clock. As I requested Aska to say the day of plenary, they must reserve the day for the plenary. Maybe I make a mistake. I said to Tuesday.
No, it's Thursday, sweetheart.
Oh, if it's Thursday.
It's Thursday at 2. So Thursday at 2. So we must be in the hotel by then.
No, we will be in the hotel. Definitely sure. That one on it, we are not negotiating. So we will have after the plenary with the department.
Oh, okay.
Thank you very much, Honorable, to advise us on that. If we before the end of the day, rectify that mistake and then send to members. So I think we are done. Before we can leave this meeting, honorable members, normally we used to, I want to tell you something, members, that the chairpersons of or chairpersons and the whips, we are getting we are being told to ask our members to tell us in advance if they are not going to do oversight with the committee. They must tell now, because if the member can confirm and the member didn't pitch to those oversight, the whip of the committee is given a mandate to make sure that if you did confirm and you didn't come, and we have booked your accommodation, we have booked you a flight, and the day before the oversight, you close your phone, we didn't reach you, you are going to pay the flight that we book. You are going to pay the accommodation and the food also. That the letter, the information that we receive from the office of the House Chair and the office of Chief Whip, to say most of the members, they didn't pitch up in the meeting that they supposed to attend after all the reservations have been done. So members, this week, if you know that you are not going, please give us the reasons and tell us that you are not going, so that to avoid Parliament to say you must pay, and to avoid the Parliament to write you a letter, a long letter. So that the information that we receive, maybe Mambibi forget to tell you. That's the information that we receive from our above offices.
Chair.
Thank you. Honorable. Yes, ma'am.
Chairperson, but also some of us in our respective parties, before any of us can embark on any oversight, we need this information that we are requesting so that our chief whips can give a go ahead for us to attend committees. Now, if we are told by word of mouth or by WhatsApp, WhatsApp is not an official document. We need to try and do things professionally and make sure that we're also treated professionally, Chairperson. So this information that we are requesting is urgent. Otherwise, we are going to be sitting with this problem where our oversight were not approved.
Thank you, Kausa. That's why I'm saying ASCA must make sure that today, we didn't want to send you the information before it comes to our, the committee. So now it's in front of us, all of us, we have seen it, we have commented on it. Now we are going to send to you today.
Thanks, Chair.
Mama Winingwenya.
Yes, Chair. Thanks very much, Chairperson, for raising this information. I wanted to submit, Chair, that I'll be leaving on the 18th. Thank you.
To join us?
No, to leave the oversight on the 18th because I've got other commitment in terms of the CWP. That is starting on the 19th. So I'll be leaving the committee on the 18th.
Okay. Now Tabang will make arrangement with us on those
thanks, Chair.
Information. Thank you very much, honorable members. Now I think it was the last item of our committee. Let me take this opportunity to thank everybody for her or his input to our committee today. We have this, this program is gonna be short, but very hectic. So we must go and rest. Today we do have a sitting plenary. We don't.
No, sure. We don't have. We've got a plenary Wednesday and Thursday.
Okay. So members, go and prepare for yourself for another meeting tomorrow if there is a meeting. Thank you very much for availing yourself in the first day. As we remember last week, we were told that everybody come back to Parliament. I hope all of you are around Cape Town to make sure that if we have a problem of network, maybe we are around, we can have our own meetings. But for now, we will continue to have our own meetings with visual until further notice. That's when we can have our own meetings in our committee rooms as the Parliament are still preparing for the committee rooms and so on. Thank you very much, members, those who are in the meeting. And don't forget to communicate with the Office of Secretary to make sure whether you are going or you are not going on time before we can do any arrangement of the flight or accommodation. Thank you, members. This meeting is officially adjourned.
Thank you, Mama.
Oh, Mama.
Long live the chair.
Long live, Papa.
This is not a rally of the ANC. This is a committee.
Record.